Well, that just happened. I'm going to wait around for a little bit and see if people jump back on the live stream. Yeah, I apologize about that, guys. Let's see. Maybe people will jump back on. Yep, we got one. Yeah, well, all right. Well, I guess we're going to go ahead and reboot. I apologize about that. My camera just froze, and I had to restart the live stream. Hopefully, everybody who was watching knows to go and check and jump on this second stream. I see a number of you jumping on, and I again apologize about that. Yeah, the camera just stopped. I know on the screen I froze, but I want to go ahead and pick back up where we left off. We're talking about what to do when tenants want to break the lease. I'll see what I can do to merge the two videos together. Maybe I'll make a part one, part two. And so here, I guess we'll just pick up from the last point where we're talking about making sure that you've got your terms in written form, because really it's the only way you're going to be able to enforce those terms is if you've got them in some kind of written form, and you certainly don't want some mix up. Again, if your tenant detrimentally relies on some oral provision that you made, you know, that's just a risk you're going to take. Always, always, always make sure you have it in writing. Tiger Harris writes, what if a co-tenant is a victim of domestic violence, but the rent is not paid? Well, while the code does allow, in certain instances, a victim of domestic violence to unilaterally terminate their lease, and there are other provisions in the property code that allow for unilateral termination, some of them having to do with repairs, some of them having to do with certain locking devices, others having to do with even disclosure of a mailing address for the landlord, believe it or not. Those provisions do allow the tenant, without your approval, to simply unilaterally, on their own, terminate the lease. If they've got a valid basis, that's fine, but they can't just withhold rent. If they're there, they have to pay rent. And so that's always a must. If they leave on that basis but owe you rent, well, certainly you can pull that from the security deposit. But their rights are limited, particularly with repairs. If they're going to stand on a repair right but don't pay rent, that right goes right out the window. So yes, that's a good question. So if there are multiple tenants and some want to leave and some want to stay, what do you do in this situation? Do you have to accommodate tenants when some of a group of them, or even just one, wants to leave? And the easy answer is no. You don't have to accommodate them at all. This happens sometimes when domestic partners break up, right? You got two people who are living together, married or unmarried, doesn't really matter. You have two domestic partners living together, and as many of these relationships do, they break up, except it's in the middle of your lease, and one of them leaves. The question is, are you forced to release that person from the lease? And usually no. In the instance of a domestic violence issue, yes, probably. But in all other instances, you do not have to release that person. And so the truth is they signed the lease and they continue to be obligated under the terms of that lease. Sometimes it happens when you rent to a bunch of college kids and two of them graduate and two of them are still in school, and the two that graduate just up and leave. Does that mean you have to adjust the rent for the remaining two and only charge them half the rent? It doesn't. And so you're under no obligation to modify the terms of the lease. The lease will continue. And you can simply keep going under the original terms of the lease. And the people who remain, if they want to stay on the premises, have to come up with the full amount of rent. They have what's called joint and several liability, which means it doesn't matter if one person pays for all four or all four pay in varying amounts. All that matters is that 100% of the rent is paid and that all of the rules are complied with. So again, in simple terms, you are not in any way under an obligation to rewrite a lease just because one or two of a group of people who are tenants on your lease decide they want to leave. James says, I've had this happen to me several times. I let two out of their lease and another tenant paid the reletting fee and the rent until I found a new tenant. Yeah, and so if you work out a deal that ends up working for you, definitely you can modify leases. But if your tenants are asking you to modify a lease where you're the only one losing, that doesn't make any sense. It's not a good business decision, so I wouldn't recommend it. Tiger Harris goes on a commercial lease, does the exterior wall include plumbing and electrical inside that wall? Can a tenant break lease if not repaired? Well, commercials are a little bit different. In a commercial lease, you're going to have to look very closely at what is in the lease. In many instances, walls are covered except for exterior walls. And so in some leases, even the roof is covered as a tenant priority. And so you're really going to want to know what your lease says and what it requires from the tenant. If the landlord's only on the hook for, say, the parking lot and the foundation, well, the rest of it's on the tenant, but that should be explicit in the lease. Again, that's commercials only. For residential property, landlord's pretty much on the hook for 100% of the maintenance of that property. All right, and the last point, what do you do when a tenant wants to break a lease? If you have a troublesome tenant who plans to sue you, report you, and publicly shame you, let them out, but do it in exchange for a written mutual release of claims. If they're saying, look, I'm out, and if you don't do this, I'm going to go here, and I'm going to say this, and I'm going to write this, somebody like that is probably worth letting go. But before you release them from the obligations of their lease, I would strongly recommend that you have them sign a mutual waiver of claims. You say, all right, fine. I won't sue you, but I want you to not sue me, and I don't want you to disparage me in any way. So along with a mutual release of claims, we're going to sign a confidentiality clause, which means I'm mums about this, you're mum about all of this. Nobody's going to talk to anybody about any of this. We're just going to be done, and we're going to walk away. And so in the event that you've got a troublesome tenant that you know is likely going to result in some kind of economic or social harm to you or damage your business in some way, let them go, but get something for it. Get them to sign a mutual release of claims so that they don't later try to sue you, and definitely get them to sign a confidentiality clause, which means they cannot disparage you or really mention anything about this lease. And by doing that, you protect yourself in the event that they, later try something. You can rely on that mutual release and agreement for confidentiality. James goes on, is it okay to require previous rental history, job length of 1 year as part of your rental criteria? Yeah, it definitely is. Just because you haven't rented before or just because you don't have a whole lot of work experience doesn't mean you're in a protected class of some sort. Yeah, you can definitely discriminate against people who don't have a substantial work history or a rental history. Joy Stanchik writes, if a tenancy ends badly and the tenant refuses to give a forwarding address, instead they want to meet at the property to receive the deposit return, can I refuse and insist they give a forwarding address? You can, because the court requires, or at least the code requires that you don't even have to consider a refund until you're given a forwarding address. And at that point, you've got 30 days. So, if they never give you a forwarding address, that provision of the lease simply doesn't apply. That provision of the code simply doesn't apply to the situation. And you can say, look, the code is explicit. You don't give me a forwarding address, I don't even have to consider forwarding a deposit to you. And why they would be so obstinate, I don't know. Because they can give you a work address. It doesn't have to be a home address. It just has to be an address where they can receive mail. That way you can, in writing, illustrate how the deposit funds, if any, were used, and then you send the balance of the deposit, again, along with that itemized list, Or if it's a full refund, you send the full refund, but you can prove that you acted with diligence and that you followed the law. So it's there to protect both the tenant and the landlord, and the tenant can't just rewrite the code because they don't feel like giving you an address. Again, they can give you a P.O. box. They can give you somebody else's address where they're willing to accept the letter, but they have to give you an address. So a forwarding address is absolutely required. Ahmed El Karim says, can a landlord sue you twice for unlawful retainer for the same issue at the same court? My lawyer filed 2 lawsuits against me. I'm confused a little bit. Your lawyer filed 2 lawsuits? Oh, your landlord. Okay. Okay. So can the landlord do that? No problem. So yes, if in the first case there was no final adjudication, this happens sometimes where a landlord has to refile because their case is dismissed. A dismissal doesn't necessarily mean that the issue cannot be brought again later. Now, can a landlord sue you, win a judgment, and then sue you for the same thing the second time? No, that's prohibited. And so we refer to that as being claim precluded, otherwise known as res judicata. But that's it's the lawyer term for it. But there's claim preclusion if the issue has been fully adjudicated. In other words, it went all the way to trial and the judge said yes or the judge said no. That claim is now dead for refiling in the same court. But if it's just dismissed, then very likely it can be refiled. So, the first case is still ongoing. Well, then again, if there has not been adjudication, there is no claim preclusion. But if you've got 2 cases running simultaneously in the same court, technically you can ask the court to dismiss the other case because it is moot. It's not real if one is still going on in one court, and there's another one in the same court. You can bring that up with a judge during the first trial and say, look, there's another one with the exact same facts. I would like to have that one dismissed. The one filed first should have precedence. Now, if the landlord means to dismiss the first one because maybe there was something wrong with it, they can do that and then rely on the second one. But they can't get 2 judgments for the same thing. That's not allowed. Okay, so let's go on to the questions here that I've got. I've got, again, about 8 of them. Dominic Wynn asks, if one tenant passes away from natural causes, is there anything to consider to do right away? Not really. If you've got multiple tenants on a lease and one of them passes away, it's kind of like one of them moving away. You're very welcome, Mr. Al-Karim. As long as the rest of the tenants can keep up the lease, the fact that last tenant is gone, he's passed away, it doesn't really change much. It would be the same if they lost their job and simply couldn't contribute. As long as the rest of them are contributing, everything is fine. Now, if you lose to death your only tenant, that's where things can get complicated. And you can defend against this by having a designation by your tenant of what to do with their stuff if ever they, as the only tenant on the lease, pass away during the rental term. And so because this can happen, I always recommend that single individuals, when they sign a lease, should also sign a designation of what to do with their stuff in the event of their death during the lease term. And so they can, identify a next of kin, and you can contact them in the event of their death, and then, give them a limited amount of time to come and get the stuff. You're not required to just hold on to it forever. And so the requirement could be, I contact you, you come and get the things within a reasonable amount of time, and then we close out the tenancy. Okay. El Alida has 2 questions. First question, rent is due on the 1st. If a landlord decides midway through the month to give a 60-day notice of non-renewal of a month-to-month agreement, would the approximate 15 days just be prorated for that last month of occupancy, or how best would you handle mid-month notices? Now, this is a good question because In some cases, your lease requires any notice that arrives in the middle of the month. You can time it to where it is effective on the last day if you're sending a 30 or a 60 or a 45-day notice. Yeah, that can certainly be timed to where you get the last day right on the last day of the month. But some leases say your termination isn't effective until the end of the month in which the time frame ends. So for example, in this case, let's say we're in the middle of April, we give a 60-day notice. And so May, June, you're going to be smack in the middle of June. Some leases say that termination isn't effective in the middle of June. It's effective at the end of June. So check what your lease says. Your lease might already address this issue. And truth be told, it's what I recommend. It makes the collection of rent less confusing, and it makes the transition off the property easier for your tenant. I always recommend saying this is your 60-day notice to vacate. It is effective at the end of the month after 60 days have come. And I'm very explicit in my notice when I say, if you get this in mid-June, this is effective June 30th. Please be out by that date. Second question, what group in the legislature defends landlords' rights? Thank you in advance for your help. Well, you are very welcome. So this happens, certain organizations do it. Certainly there are large enough landlords that they can send their own lobbyists to Austin to lobby for legislation in favor of landlords. But the associations do that, realtors associations, so Texas Realtors, the Texas Apartment Association, and other larger groups that represent investors and home buyers often send lobbyists or testify in certain hearings for legislation that favors landlords. So I hope that is helpful. Let's see. James writes, check out House Bill 32. Yeah, if there's something cooking up in the State House right now, I recommend you check it out. I tend to wait to see, what legislation actually passes to the governor's desk before I really get interested, because a whole bunch of stuff gets tossed around. But unless it makes it to the governor, it almost doesn't really matter. But yes, if you have an interest in going and speaking to your legislature about certain things, then I always recommend that. Dollar Dude writes, evicting a tenant now. Filed a motion asking for the summons for damage to be served via posting since I had evidence they knew. Granted, the server said he'd never seen a judge agree to that before. It's actually pretty common. The court will attempt to serve an individual at the property, and in evictions, it is more common for a tenant who simply doesn't respond to a constable who comes up and knocks on the door to serve an eviction. It's quite common for the court to sign an alternative method of service, which is the constable goes and they tape the citation on the front door of the property, and then they also deliver it through the U.S. mail, and that constitutes good service. It's in the code that way because evictions are supposed to be speedy, and so you don't even have to file a separate motion. If the court has been unable through the regular means to personally put the lawsuit in their hand, the court will typically grant alternative service in these situations to make sure that the petition is served on the premises and then mailed to the tenant. Okay, Tiger Harris asks, does exterior wall include plumbing, commercial lease included plumbing and electrical? Can a lease be broken if landlord does not fix it? Potentially. Again, with commercial leases in particular, it's very, very fact specific to that lease. You're going to have to see if the failure of the landlord to make a repair, is grounds for termination of the lease. Generally speaking, it is not. And it has to come down to what the landlord is even on the hook for. And so what might occur is you've got some issue. If it affects the tenant and their business, they might do better just to pay for it themselves and then maybe sue the landlord for compensation for having to cover something that the landlord was otherwise obligated to pay for. But again, with commercial leases, it's very, very much in that lease, who has a responsibility for certain repairs and what constitutes a right for termination. And so I couldn't answer that question generally because, again, it's very specific to the lease. Okay, Paul Salvo asks, can a city put forth ordinances without a community vote on the changes? Well, yeah. I mean, the community vote is the election that put that city official on city council. So absolutely, if they're voting on something that's going to affect everybody, they've already won the vote. And so you don't have to have a separate vote for things that they vote on. That one time, that one race that they won gives them that right or that authorization based on the community voting. So Andres Martinez asks, what's your take on increasing demand for room rentals? From a lawyer perspective, how can investors defend themselves from the city shutting down these room rental properties? They are creating homeless people. Well, Mr. Martinez, yeah, there is demand. In fact, I've seen companies that now do this where they kind of facilitate or they specifically manage properties for individual room rentals. And so it is becoming a more popular option. The unfortunate thing is you probably can't prevent a city or an HOA even from restricting rentals in this way. The state of Texas has allowed municipalities to put these restrictions on and homeowners associations to put these restrictions on. It's very difficult. So one way to protect yourself against a municipality from doing it or from a HOA from doing it is simply by having property that is outside of the municipality or outside of an HOA. That's really the only way to avoid that altogether. Generally, a county isn't going to do it, but even a county could institute certain limitations on how property is used. But this is mostly going to happen within city limits. And so, and here's the thing, that's where they're most popular, right? Because people want to be close to where they work. And so they want to be in the city. Unfortunately, if a city code prevents that, then that's no longer an option. And it's kind of difficult to defend against it. So Tiger Harris writes, can a co-tenant break lease if victim of domestic violence but rent not paid? Can tenant be evicted? Yeah, unfortunately, even in the unfortunate situation where a tenant is the victim of domestic violence, if the rent's not paid, the violence is not technically a defense to non-payment. It's a terrible situation, and you might have a sympathetic judge who won't issue the eviction, but technically there is no defense for non-payment just because of the incidence of domestic violence. If the rent is paid and the tenant follows the code provision that allows for early termination, that's possible, but they got to be current on the rent. Dollar Dude, I live in Florida. Process server said that court 1 for possession could be served via posting, but court 2 for damages has to be served personally. Maybe it's different down here. And it might be definitely in Texas, alternative service just by posting and then mailing is quite common in Texas and happens a lot here. It also helps to push these evictions faster. But hello from Florida. Hello to Florida from Houston. All right, let's move on. Shayna Griffin Broomley asks, any restrictions on investing deposits in a short-term investment like a CD? In Texas, there are 0. In fact, in Texas, you don't even have to put security deposit funds in an account. You can put them, in a sock and toss it under your bed as long as you keep track of the funds, you're fine. And so as long as you can prove that you have held to account the amount that's in there, in that sock, and you return all validly refundable amounts to your tenant in a timely manner, you're fine. But you could take that money and you could invest it and you could keep those proceeds. Again, you're required to refund what is validly refundable. You're not required to collect interest and send that to the tenant, but you can collect interest and you can keep it as long as you account for the strict amount of the deposit back to your tenant or apply it in accordance with state law and your lease. Number 7, Edward John Vaught asks, thank you for all the information and help you provide Texas landlords. You're welcome. I often hear the landlord should not accept rent once the eviction process has started. Yet, in the Texas Justice of the Peace desk book for eviction, page 45 states, A, additional requirements for judgments in residential evictions for non-payment of rent. Note that these requirements apply to any eviction from a residential property where the grounds for eviction are non-payment of rent, even if the plaintiff didn't exactly seek to receive monetary award of back rent. For example, Jim doesn't pay his rent when it's due. Landlord gives a notice to vacate, then timely files an eviction suit. During the eviction process, Jim pays his back rent. However, the landlord can still proceed with the eviction since Jim didn't timely pay rent as provided in the lease. At trial, no new rent is yet due, so the landlord wouldn't be awarded any back rent, but the grounds for eviction would still be non-payment of rent. So the requirement discussed here, as well as on page 60, would apply to Jim's eviction. Thank you. So, Edward, yes, that's precisely what the black letter law says, that as long as there was a valid cause for the eviction prior to the filing, even if there's a change in circumstances after the filing, that cause of action remains, so long as the tenant is still in possession. Because here's the legal ramifications of what's happened. That notice to vacate is an immediate termination of the lease. And whether you gave 3 days, 10 days, or 30 days for that tenant to vacate, the fact is on the day you handed over, the day you delivered the notice to vacate, that lease terminated. Now, can it be revived? Absolutely it can. But the fact of its termination means if you terminated the lease and if the tenant failed to vacate and if you filed your eviction lawsuit, you should be absolutely 100,000% entitled to a judgment for eviction. However, there are plenty of judges who disagree with that analysis. Even though that's what the black letter law says, there are certain judges out there who simply see that as unfair and will not issue a judgment in those cases. And so because of that, I tend to recommend to landlords, do not accept rent after you have filed. It could result in your case being dismissed, right? Because the judge, may not agree with this legal analysis that, well, you accepted the rent, but you still want me to kick them out? They're paid through the end of the month. How are they evictable? And those judges make a fair point, despite what the black letter law says. And so is it worth the risk of accepting the money? Well, you got to ask yourself 2 questions. Number 1, how badly do I want this eviction? Do I want the money more or do I want the eviction more? If you're leaning toward the eviction, then accept no money. If you're leaning toward the money, then take whatever money you can get and roll the dice with whether or not you've got a judge who's willing to accept and grant your eviction under these facts. The second question is, if I do accept this rent, what's the likelihood that the tenant is going to default next month? If the answer is pretty high, then why take the rent? You're just going to do the same thing month after month after month. and I see landlords do it. It's not worth it. It's not worth it. And so ask yourself, which do you prefer, the rent or the eviction? And if you do take the rent, is it likely you're just going to be back next month with the same thing? If that's the case, then reject the rent. Again, it's not super difficult analysis. It's either worth it or it's not. Sometimes money in the short term causes more loss in the long term. So don't take a short-term gain at the expense of long-term losses. So James says, thank goodness for Texas. Amen, brother. Amen. All right, here we go. Last question. Ketvin asks, could you please comment on a landlord's right to refuse service animals if the landlord self-manages and owns only 3 properties? Can you address this? In recent posts about service animals, seems several people are in this group and here only to bully landlords into believing they do not have rights. I see this in Airbnb groups all the time. Several non-landlords get together to misquote the laws. These individuals are only in the group to troll posts about service animals. And that may be true. But there's one thing that I always caution people about, because yes, the Fair Housing Act does have an exclusion to its terms for smaller landlords. It also applies to religious organizations and exclusions for senior living establishments. But if you're neither a religious organization or a senior living home, you're just a regular landlord that's got 3 properties, the exclusion applies if you don't use a broker to advertise those properties. And the code isn't super clear on the distinction of what a broker is. Would Facebook Marketplace constitute a broker? Well, not in the traditional sense, but if you give an expanded definition of what that means, I don't know. And so the question is, should you roll the dice if you do any kind of public listing of any kind? Because if you're listing your property online, you may be ineligible for this exemption. If everything's done, with a handshake, you put a sign out, you take phone calls, you do all of this stuff yourself, you're probably eligible for an exemption. But what I tell landlords is the following. You should follow the law as though the exemption doesn't apply, especially if you're razor close to the edge. And the reason is it might actually be more expensive presenting your defense than the claim itself. Additionally, as long as you're on top of it, the best way to protect yourself against service animals, I can offer a number of things. Number one, if somebody shows up with a bogus service animal claim, sniff that out and reject it. You have the right to, confirm whether or not, their claim of a service animal is legitimate. In many instances, it's all talk. They claim they have this service animal. They claim this is an ESA, but they can never produce any verifiable evidence of that fact. So that's one layer of protection for you. The second has to do with the fact that you have the right to protect your property against even an emotional support animal that's going and creating damage on your property. So your second layer of protection is, no, the fact that it's an emotional support animal doesn't mean they get carte blanche and they're allowed to destroy your property. You can enforce restrictions on your tenant for the harm caused by that animal to your property during the lease. You don't have to just wait and say, well, they didn't even pay a deposit. Doesn't matter. If that little animal caused damage to your property, then you can charge that damage. I would go in and repair the damage and then issue that bill immediately to the tenant and say, if there are repeated instances of your animal damaging the property, you will be evicted for damage, not for having an emotional support animal, but instead for not controlling their emotional support animal from damaging the property. So you've got multiple options here when people show up with emotional support animals. And so the truth is, we should probably just get used to this exemption going away, because it really seems as though that's where things are headed. Ultimately, this exemption will go away, and will maybe only apply if someone has a single rent house. And so if you're already pretty close to the edge, I would just assume that it applies, and then just use these other methods to make sure that the people who do have service animals on your property are taking care of your property in accordance with the law and in accordance with your lease. James says, yeah, you can see the writing on the wall with tenants when tenants start paying late. Yeah, I mean, any late payment, my rule is 7 days. If you haven't collected all of the rent within 7 days, you're headed down a bad path. You should issue a notice to vacate and move on from that tenant. JVB says, hello, please examine the Texas legislature for upcoming new laws about landlords. Yeah, I mean to. Usually around August is when I start looking, because that's when you know what has passed and what is likely to take effect during the legislative year. So I want to thank all of you, particularly those who hung around through the whole thing. I apologize about the technical issues that we had earlier today, but I do want to say thanks so much for joining us on this live. We'll be back next week, and next week's topic, I can tell you, is: can I limit pets in my rental to just dogs and cats? So we're going to be talking about pets a lot next week. Those of you who have pet questions, feel free to bring them next Wednesday. I'm happy to talk about all of those things and whatever else pops up during the live. But for now, I want to wish you all a great rest of your week. And until next time, landlords, happy leasing.